So about Chevron for a second. Tell me how you think Loper Bright changed the landscape on administrative law, specifically just on the level of deference that needs to be applied under the APA to an agency.
Sure. So before Loper Bright, the Chevron regime reigned, which was supposed to mean, according to the precedent, that if an issue was not directly and conclusively resolved by statute, which is itself a question that's often in the eye of the beholder, the agency could then come in, and so long as whatever it did was reasonable, you would go with what the agency did. It would be effectively legally binding and could control the case. That had been criticized for a long time. Loper Bright stepped in and said, no, the APA textually commits interpretation of legal rules to the courts, and therefore judges cannot pass that off to let the administrative state effectively make its own rules unless the law does that very clearly, as some laws do. And so Loper Bright took away that deference.
Unless it's committed to agency action or something like that.
That's right.
Yeah. No, that is a good point. And because otherwise you end up in a circumstance in which the U.S. government or a U.S. government agency is there with a stacked deck. It has to defend things only to a less significant degree relative to other litigants. And where the lawmaking power is concerned, this is especially concerning. So post-Chevron, after Chevron's demise, is the major questions doctrine still good? And how, if at all, has major questions doctrine been changed by Loper Bright?
So that is currently a subject of a great deal of debate. Some people look at Loper Bright and say, look, the major questions doctrine was adopted mostly to try to take the edge off Chevron because of the extreme way it empowered administrative agencies. Other folks say, well, that's a different issue. The question whether a question is major and can be entrusted to an administrative agency still has a role to play. So I mentioned the idea that some laws say an agency can make a rulemaking type X, Y, or Z. Some people will say, well, the major questions doctrine could still help you determine whether an issue falls within that delegation. Right. And so that's working its way through the courts now and being worked out case by case.
On some level, some of this tends to focus back inevitably on the intelligible principle concept and what the intelligible principle consists of. Some have suggested that perhaps one way around that might ultimately lead the courts into saying that the intelligible principle must mean more than simply identifying an agency and narrowing the field in which it may operate, and to actually confine it in a way that provides notice to the individual whose life, liberty, or property interests might be impaired by failure to comply with the federal rule of law. Article 1, Sections 1 and 7 make clear that we are the lawmaking organ of the U.S. government, and one could conclude that one's not on adequate notice unless or until one's affirmative legal obligations are made clear by the Article 1 organ. I assume you wouldn't dismiss that as outside the possibilities of where the Supreme Court might ultimately go with this.
No one would add that there remain at least two binding precedents that did in fact strike down laws on grounds of delegating effectively too much unbounded lawmaking power.
Right, right. And the fact that we can't identify more than those has, in the eyes of some, including some currently sitting on the Supreme Court, that perhaps we ought to take another look at it. Mr. Olson, let's talk for a minute about universal injunctions. What's your understanding of the judge's equitable authority to enter a universal injunction after the Supreme Court's recent ruling in Trump versus Casa? Are universal injunctions still permitted after that? And if so, when? What restrictions fall on them?
Senator, my understanding of universal injunctions is that they are generally not permitted after Trump v. Casa. The equitable relief that a court may provide is limited to the parties before the court.
That likely inheres in the nature of equitable authority itself. At equity, that is the whole point of equitable power, is that other forms of relief aren't sufficient. Money damages aren't sufficient. If somebody from the government is about to bulldoze your home. You don't want damages after the fact. You want your house not to be bulldozed. It's specific. It's unique to that case. So it lends itself well to that.